Welcome to another episode of Boom and Bust. I'm your host, Tony Clement. I'm here at the News Forum where all voices matter. Well, the Online Streaming Act is now signed into law, but the debate about its consequences has only just begun. To help assess its impact on creators and users, we've invited Joanna Baron to join us. She's the executive director of the Canadian Constitution Foundation, a legal charity that protects constitutional freedoms in the courts and public opinion. I happen to be a board member of this foundation. Welcome to Boom and Bust, Joanna.
Great to be here with you.
So I guess the first question, Bill C-11 or the Online Streaming Act is now law. What happens next? How does the implementation process go from here?
So basically now we go into what promises to be a classic Canadian long consultation and regulatory phase. So there's going to be 9 different regulatory phases that will be happening, conducted by the CRTC, to go into some definitions of what is Canadian content, of how exactly they're going to implement the bill, which used to be Bill C-11, is now, of course, the Online Streaming Act. So basically, we have probably about a 3-year road ahead of us until we know exactly what this act is going to look like put into practice.
Does that strike you as odd that this whole debate and this whole bill went through 3 readings in the House of Commons and 3 readings in the Senate and then back and forth, and some basic definitional issues have not been figured out yet?
Yeah, absolutely. And this is something that I've thought about a lot, and we've thought about a lot at the CCF, particularly because there were big issues with the bill as proposed that I'm sure we'll get into, that we really would have liked to have seen clarified at the law stage and not just delegated to the regulator. So it seems like, particularly given that this was a 2-year process where there were all kinds of issues flagged by the media, by legal experts, by former domain experts like former CRTC chair Peter Menzies, and there were opportunities to clarify some of the ambiguities. As constitutional lawyers, we like to see these protections built into the law, and we certainly don't like to see obvious unconstitutional issues embedded into the law. It's not good enough to say, the bureaucracy will deal with it.
So let's delve into that now then. Tell us about what your continuing concerns are about the bill and about the CRTC, their direction when it comes to regulating creators and therefore affecting users.
So first of all, is we have to say that a lot remains to be seen, right? Exactly how this will be implemented will be decided during the CRTC regulatory hearings and consultation procedures. However, there are 2 major issues that I'll just highlight for now. The first is the definition of Canadian content. So currently, in order to qualify as Canadian content, not only is there a sort of complex matrix of salaries paid and different individuals involved, but you also have to be certified as a Canadian content producer, which anybody who's aware of the current digital content landscape, Twitch streamers, YouTubers, TikTokers, some of whom have audiences that are bigger than the CBC, very seriously, that they're going to go through this paperwork process, sending paperwork over to Gatineau. It's sort of just laughable. And so we would have really liked to have had a modernized definition of what Canadian content is. Why that's relevant is, of course, that the whole point of this Online Streaming Act is to prioritize and protect Canadian content. The second issue that has been a bugaboo for some time is the issue of user-generated content. There have been various denials, especially by the heritage ministers who shepherded this bill, that the intention was not to regulate user-generated content. However, when the bill was in the Senate proposed a very tailored exemption for user-generated content that still responded to some of the concerns that the government said they were going at with that particular provision of the bill. And it promptly was scrubbed off when it went back to the House. So you can draw your own conclusions about why that might be.
Yeah, so there's some substantive issues that still have to be addressed.
Yeah, certainly.
Fun fact, because we're going to go to a commercial break, but of course I'm very familiar with the Canadian content regulations. that the CRTC have had for decades when it comes to radio play for Canadian musical artists. And at one point, Bryan Adams was not considered Canadian enough, and they had to carve out a specific exemption for Bryan Adams because it was ludicrous that Bryan Adams wasn't considered Canadian enough. That just tells you everything you need to know about some of these regulations. We'll be back with our guest, Joanna Baron, after the break.